So much. I'll see you a little bit later.
Yes, sir.
Judge, will you be going to the service? Judge,
No.
are you gonna be going to the service? Promote?
Just 1 second.
Yeah.
Sorry.
Are you going to most service today? It's today.
Oh, I didn't know it was today.
Yeah. It's on Austin Highway. I forgot the name. Yeah.
Text it to me.
I'm sorry?
I have texted it to me. All
You
right,
got it?
thanks.
Okay. So he'll get it to you, Judge.
All right,
I don't think
thanks.
I have it.
Yeah, you do. I mean, from our time, here's here it is.
Hmm?
From our time on our famous case together.
Oh, okay. Thank you.
You're welcome. What day did you do that, Norma?
July 11th.
All right, thank you.
And we're in charge.
All right, are the parties ready on Mercado? All right, the court, Brittany, you ready?
Yes.
Court is calling 2021 CR 7975W, State of Texas versus Daniel Mercado. Can I have parties announced for the record for the state? Brittany Sparks. For the defense? And are you Mr. Mercado?
Yes, Your Honor.
I'm going to show you two documents. The one is entitled Motion to Revoke Community Supervision. The next is First Amendment Motion to Revoke Community Supervision. Did you review those documents with your attorney and did you understand them?
Yes, I did, Your Honor.
Are you the same Daniel Mercado who was placed on community supervision in 2021 CR 7975W for the offense of evading arrest, detention with a vehicle on August 31st, 2021 for a term of 3 years? Is that you?
Yes, Your Honor.
Right, state?
Yes, Judge, violated condition number 1 on or about the 15th day of April 2022 in Bexar County, Texas. The defendant, Daniel Mercado, committed the offense of possession of controlled substance, PG1, in violation of condition number 1.
How do you plead to that, true or not true?
True.
Violated condition number 1 on or about the 15th day of April 2022 in Bexar County, Texas. The defendant, Daniel Mercado, committed the offense of tampering government records in violation of condition number 1.
How do you plead to that, true or not true?
True.
We'll waive all other violations.
Any objection to the state's waivers?
No.
Mr. Mercado, did you understand by pleading true to violation conditions 1 and 1, court could find it true, grant the motion, and sentence you up to 3 years in prison and up to a $1,500 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations of conditions 1 and 1?
Yes, Your Honor.
Court will find 1 and 1 true. Is there an agreement?
No, Judge, the state has a recommendation.
State, what are you requesting?
We're asking that you revoke his probation and sentence him to 2 years in PDC.
Defense?
Your Honor, Mr. Ricardo wanted to address the court.
All right, Mr. Mercado, that means that you'll be placed under oath and subject to a cross-examination. Do you understand?
Yes, Your Honor.
Knowing that, do you still wish to speak to the court?
Yes, Your Honor.
All right, if you could raise your right hand for me, please. You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God.
Yes, Your Honor.
You can lower your hand, state your name for the record.
Daniel Mercado.
All right, defense.
Are you descendant of Mercado who was placed on probation in this court?
Yes,
Okay, what were you placed on probation for?
for evading arrest with the motor vehicle.
Did you report to the probation officer's order?
No, I didn't.
Did you do anything that would allow one to say that you're beginning to comply with the conditions of probation that had been ordered when you were sentenced?
Since then, I've had.
Not since then?
No, I didn't.
Okay. So you just blew up going to probation, is that right?
Yes, yes, sir.
Okay. Do you want to explain to the judge what happened and why you did that?
Yes, sir.
Please go ahead.
Yeah, when I got out on probation, I wasn't in a stable situation. I needed help. I have a gambling addiction, and the gambling addiction is really, really bad. Drugs are there when it's there. I've already kicked the habit of cocaine and drinking. I have never really had help. for substance abuse or gambling, which there's not much of. But when I did have a help for the cocaine to a psychiatrist and psychologist, I kicked that habit. I kicked my drinking habit when I had got my second DWI. I know that with help, I can overcome and succeed and be a productive citizen by overcoming my addiction of gambling, which led to the possession of the drugs. I just would hope that the court sees that and gets me help as opposed to sending me to prison. I'd be willing to go on intensive supervision. I do have a support system in place now since reflecting, and I've enrolled in drug classes and let the counselors know in the jail that my real addiction is gambling, and they've given me a bunch of resources for it. I'm not looking to shy away from, I'm taking responsibility for what I have, but I really want help. I even asked our officers for help for that. So if I can get the help, wonderful. If I still go to prison, you know what, I thank you, but I just would like to try to get some help.
All right, anything else?
Just a brief argument.
All right, state any questions.
No, Judge.
All right, so Mr. Mercado, as you know, from being in this court, whatever anybody has a problem with, I always ask them, is there anything else when I place them on probation? Is there anything else you need? Let me know. And what I can tell you is when you were placed on probation in this court on August 31st, because I write everything down, and they wanted the MRT course, which is to teach you right from wrong and whatever you need, regular UAs. I did field visits. And the reason, if you didn't have a drug treatment in here, the reason why you didn't have it is because you didn't tell me that you had a drug treatment. And I know, I always ask people, is there a drug issue? If you're drug tested today, what the result's going to be. So you didn't tell the court you had a drug problem. So I won't say like, I don't appreciate when people come before me and they act as though help has not been given, or that I have not, or the court has not tried to give help. Because the only reason why you don't have drug treatment as a part of your conditions is because you told me you didn't have a drug problem. And the other thing I do know, and there are plenty of commercials out there, if people have a gambling problem, guess what? They put up there the 1-800 number. And if you had a gambling problem, all you had to do was pick up the phone and call your probation officer. And I tell everybody that who's on probation, because I take no pleasure in revoking people, sending people to prison. I put people on probation because I think you're going to be successful at it, and I hope you will be. If I thought, and I had a crystal ball, and if this were the minority report where I had pre-COVID, I would be like, pre-cogs are saying, you're not going to do well on probation, you're going to violate, so I'm not giving you probation. But I gave you a chance with probation, and you had all of these conditions, and based upon the questions from your attorney, you did nothing. So now you're just here before me saying, I have these problems that you've never admitted before. And you come before me and you're on probation for evading, you come before me, and you pick up 2 new cases. So, I mean, that's where we are. All right, I'll hear argument.
Yes, Judge, based on the fact that he was placed on probation in August of last year and picked up these new offenses just a few months later, that's why we would ask that you revoke his probation and sentence him to 2 years.
There's a notice to state that I say this respectfully, is only asking for the same 2 years they were asking for before. But I did want to bring to the court's attention and highlight for him that this is the first time this man has apparently asked anyone for help. He said, I have a problem. He knows if he doesn't get help, he's going to come back before this court, if not in front of some other tribunal, and have to deal with whatever his problems are then. And he looked at me and I told him about my problems. And he looked at me and said, I'm ready to step up and see what can be done to help me or what I can do to help myself. That's why I stood here with him while he asked the court to consider getting him treated for this problem as opposed to just sentencing.
All right, so you want to be truthful with the court as far as this is the first time you're saying you have a drug problem?
It's the drug problem. It comes with the addiction problem of gambling.
All right, you want to admit to the court that this is the first time you're saying you have a gambling problem?
I didn't tell the court last time. You're absolutely right. I did not tell the court last time. And, I didn't have the support system. And I failed to let the court know and about that. And when I initially missed the probation in the beginning because I wasn't stable, you know what, it was hard for me to kind of turn back, but I started getting steps of getting a good job. But I just, with being on the run, you know, I just didn't know where to go. And then getting locked up in here, you know, I've had time to reflect and know that, yes, I did wrong. And I wanted, that's why I enrolled in classes for drug treatment and whatnot, without knowing what's going to happen here, you know, and I'm not doing it to benefit. I'm doing it to try to benefit myself, not to get out of a sentence or go into prison or whatnot. I want to benefit myself and change drugs. I'm 46 years old, and I've tried to say that I can, you know, balance the drugs and the good life and this and that. And it's never worked for me, you know what? And it's not going to work for me again unless I get treatment. You know what? That's my thing, is I need to abstain from alcohol and drugs. And it's not, I can't do a little bit here, do a little bit there, and I'm working. It's not going to work for me. I'm going to be back in front of you if I continue to do, you know, on that path.
If I may. So you're telling the judge, this is the first time you've gone before any tribunal and admitted that you have an alcohol and drug problem, and you are asking for help.
Yes, I am asking.
And before this hearing, I told you, did I not, that help may not involve going back to mama's house or wherever you're headed. You may have to go to a facility or you may go to prison. You were given that information.
Yes, sir.
And you chose to continue to follow this path.
Yes, sir.
Thank you. That's all.
All right, any other questions or just argument?
No, Judge, just like the defendant said, he never reported to probation, which is why we're asking to sentence him.
All right, you can have a choice. Either way, you're going to a lockdown facility. You can either go to safety, and I'll explain to you with safety. That's a 9-month program. You're gonna be in lockdown, and there's a waiting list for that. And then you'll be back on probation, or either the state is offering you the minimum, which is 2 years. All right. So the court is going to grant the motion, revoke, sentence you to 2 years in the prison. There's a $1,500 fine, time and money to run concurrent. Give you credit for any time served. And probation, did he pay restitution? Well, I'm assuming he did not. So there's restitution to AT&T. Do we know how much the restitution was? Does anyone know?
To AT&T?
Your Honor, it didn't have it in the probation files on if it was ever determined.
All right, any restitution to Enterprise? Does anyone know the amount for that? And that was from cause number 2021 CR 3940 that was taken in consideration. And the restitution to AT&T was from CM 83530 that was taken in consideration.
No, Judge, it doesn't look like it ever got a value.
All right. Then the court will sentence you, as previously stated, to 2 years in the prison, $1,500 fine, time and money run concurrent, give you credit for any time served. If you want, they have what's called a therapeutic community. At the therapeutic community, if you're accepted, they will address whatever issues you may have.
Thank you, Your Honor.
And
Alright.
Judge,
Yes.
with his plea of true to the new number ones, we did agree to TIC those.
Okay.
It's gonna be Night Mag 657536 and County Court cause number 683020.
657536
Yes, ma'am.
and 683020.
Yes, Judge.
Thank you. All right, and I will request the therapeutic community. They're not going to give you the therapeutic community if you don't ask for it, and then they still make it. I give it to you. So it'll be completely up to you whether they start the process. Do you understand?
Yes, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
You have a limited right to appeal, and that right to appeal is not the fact that you are on probation, but the right to appeal as far as the allegations in the motion. Do you understand?
Yes, Your Honor.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
You're welcome.
Excuse me.
Yes.
Thank you.
Mark Anthony Rodriguez. Yes.
I'm gonna get indicted. This is part of
If she does.
that situation. Do I file an answer for this or let it go?
No, that has to go downstairs to county court at law number 15.
Has to go downstairs, what?
It has to go to county court at law number 15.
I'm sorry, but there's no violation of anything to do this.
I'm sorry?
She's asked me to drop it off for her and I will do that. I just want to be sure I haven't violated anything by dropping off the voucher.
No.
Thank you. My excuse.
Well, I mean, you're not violating anything by dropping that dismissal off.
Thank you.
Yes.
Well, Judge,
Hi.
I was appointed on Mark Rodriguez. He had prior counsel. He hired an attorney, Ray Martinez, who withdrew.
Mhm.
And the moment he withdrew, he off bonded Mr. Rodriguez,
Yes.
and he was unable to secure a bond during this time. I informed him of court today. He hand wrote that he needed to be here today, reset form.
Mhm.
But he said that he had COVID symptoms and didn't want to expose the court to that. I understand that he already has a warrant. I could not obtain documentation. I'm just asking if the court could either perhaps recall this for him to appear on Zoom for another date, or if the judge is going to take action on the bond amount. If we could avoid remand without bond, as he had appeared previously, he did secure counsel. And there are some motions I filed that needed to have heard before the courts before it goes to trial.
All right, what I'm going to do is I'm going to issue a judge's warrant. I'll remand him without bond. If he makes an appearance or either provides you documentation that he is ill, then the court will reconsider. But he's not here.
I
He needs to
understand.
be here.
I need him here so I can have my motions heard also.
Yes, all right, so we're going to go on the record briefly with that. Court is calling 2019 CR 6497A, State of Texas versus Mark Anthony Rodriguez. Can I have parties announced for the record for the state,
Ryan River for the state.
for the defense?
Joseph Stateson.
All right, this case was set at 9 a.m. today. It's now 2:31 p.m. Defense, you stated that your client informed you that he wouldn't be able to be here for medical reasons, and the court wanted documentation of that medical issue. And what's the result of that?
I do not have any documentation. I reached out to my client. He is unable to provide any at this time.
All right. So what the court is going to do, I know that on this case, I believe that there was an affidavit of surety, to surrender surety. Is that correct?
I believe the prior attorney who was retained when he withdrew, by my understanding is the system has to off bond him when the hired attorney withdraws.
So what I'm going to do is I'm going to issue a judge's warrant and remand him without bond. If you're able to get that documentation or proof to the court, I will most definitely reconsider that.
Mhm.
But he should be here because
Yes,
it's a
Judge.
trial setting.
I understand.
All right. And then just confirm with Ms. Ferguson on your motions once he presents himself.
Yes, Judge.
All right. Thank you
Thank
so
you.
much. Nola, so that Mr. Mark Anthony Rodriguez won't fall down in the system or go missing, can you just give it a 30-day reset, but they may come in for a different date? And what date will that be? Okay. Mr. Stateson, so that it won't fall through the system, we just set it for July 6th, but you can, of course, bring it in earlier than that.
I would like to bring him in earlier. Thank you, Judge. Appreciate it.
All right, thank you. Have a great rest of your day.
I'll be here tomorrow. I'm covering Joanne Doyle's case tomorrow. So
Okay, all right, thank you. See you then. Can I just put a judge's warrant on that? Who are the parties on Ricardo Martinez? All right, and what is happening with Ricardo Martinez?
Judge, it's a first setting. I did get a. We did confer this morning. Mr. Martinez was late because I didn't get notice of the setting until Friday afternoon. And I couldn't get a hold of him all week, and I finally got a hold of his brother. And Mr. Martinez was working in Uvalde, so he had to drive in this morning from Uvalde. He got here before lunch, but he wasn't here at 9 o'clock.
All right, you need to just make sure you're on time, you understand?
Just, that's you.
All right, so you have, do you have all your discovery?
I believe so, Judge. I've gone through it. 6 hours.
Was it an offer tender?
I'll have to double check. I don't remember if there was one written in the file.
All right,
I
let's
can
see.
check that.
Family violence, was an offer tendered on Ricardo Martinez?
There's nothing.
Okay. So, Ms. Ferguson, on Ricardo Martinez, if you can give me a 30-day reset. And all right, so we're gonna be back on July 6th. On July 6th, the state will be prepared to make you an offer. And then the next date I give you will be your plea deadline date. You understand?
Oh, it's going to.
Raymond Martinez, I'm writing it in ink. So I'm like, don't say I'm gonna be somewhere else because I'm writing with an ink pen.
I'll be here.
All right, so they'll give you a reset form.
Okay.
Kendall Blunt. Who's the attorney for Kendall Blunt? I'll just have a seat.
I'm right here, Judge.
Oh, come up there.
That's why they were next to each other.
All right, what is happening with this case?
Judge, we've been conferring for a while. We've already got our expert appointed. We already have a report from the expert. The reason I filed a continuance for today, Judge, is my expert. I had checked with him in advance to see if he was going to be available to testify this week, and he was not. And he sent me an email with his schedule. I've shared that with the state so we can make sure that we set it on a date when he is available.
Well, has he been subpoenaed?
I mean, I haven't subpoenaed them.
I did not, Judge.
All right, that's how we get people here.
Understood, Judge.
So-
We're still relatively early in this process. This has not been, this may be the first time we're actually out for trial, when everything's been.
I mean,
Sure.
we're not early.
I know, Judge, but to explain some of that, Judge, we were many settings into the case before we even got an autopsy report. The state rushed an indictment because I had filed an examining trial. We had many bond reduction hearings on this case. It now appears we're moving towards actually trying it. And we're getting all our ducks in a row. Just not ready to do it this week.
So what don't you have?
My expert. I've also had the last thing you did, Judge, was you ordered an investigator, and he's already gotten on the case. He's visited with my client. I've given him his marching orders. He's also in place and should be ready to go when the case comes to trial.
All right, before we do any of this, I want an acknowledgement of discovery now, because I don't have time.
Okay, Judge.
So we'll continue to converse on this once I get my acknowledgement of
Understood.
discovery.
And Judge, in the meantime, I do also have on your docket today a contested MTR. We're trying to move towards a possible plea of true with an explanation, if you will,
Okay.
so that we don't have to have now I have testimony, but if I could step back for a minute to try to finish that as well.
Yes, yes. All right, Mr. Blank, just have a seat. Sean Foster. right, so what is happening with Mr. Foster? I have today is plea deadline date.
There's a discovery snap week. There's a little bit more discovery I'm asking that they get for us before we commit to a plea. So
Okay, and which discovery is this?
I'm sorry,
Which discovery is this?
on what case?
No,
Or
no, what is
items?
the discovery issue?
Some photographs and some additional reports.
All right, and state where,
I don't think they should take long.
So I sent an email to the officer request to see if they even exist this morning during docket.
all right, do you have an idea when you will have that?
He responds pretty quickly, so I would imagine we would know an answer this week if it's available, and if it is available, I would still think we would get it turned over within a week.
Okay. So this is what we will do. Because I know you're gonna be out of town.
I am. If we could come the week of like the Wednesday, the 22nd of June,
All right.
or somewhere in that range. And
Ms. Ferguson? Defense is not on the 22nd, it would have to be the 23rd.
that's fine.
Are we able to call Mr. Foster back for the 23rd? All right, so we'll do June 23rd.
Thank you, Judge.
All right,
Can we be
June-
excused?
Yes, Ms. Ferguson give you a reset.
Yes,
form.
I'll get it.
Are the lights dim in here?
Did you just put some?
I just feel like they just dimmed on me.
No, we just have to smell it twice. I hope you brought it. No.
Mhm. I don't know, who keeps touching that?
Cut it now. Yeah, because there's just a hint.
Yeah, I'm like, who keeps touching the stuff
I don't
that's here?
know. Put your camera just so I can see you. There we go. There. I don't know what happened. I don't know. There. You're a fool. Okay.
Okay. You need to turn on the camera. Yeah, I don't know who keeps moving that. All right, where's Kenneth Jones file? I see the state on, it's criminal trial division. There's a request. There's a request for, but it's not in the right order. It's not sworn to. Y'all are gonna have an objection to that. or not.
Okay, let me look at it.
Thank you. Yes. Yes. I know, I want the judge's warrant, and I want him to remain without bond.
Okay, I'm recalling it. Put this one.
Okay, thank you.
We're ready, but whatever, I mean, whatever you want to do, Judge, if y'all want to push him. It doesn't sound like it's gonna be a plea, so
Okay.
we're okay either way. We're ready if need be. If not,
And
it's
then
not the end of the world.
also, if you can look into this one, this one, because I don't know if this person has been seen or not.
Judge, I do remember the guy who didn't show up on that manslaughter today.
Mhm.
I pled him when that started. Has he been having issues?
Yes.
It's funny that I really thought that guy was going to do well on. It was a really sad case. He shot his best friend. He was the only one who stayed. They were smoking marijuana and they were playing with a gun. And it,
But what it is.
I think he's had drug issues since, which surprised me because I feel like the guy pled right away. He came to court in a suit all the time and
Mhm.
was real.
I'm trying to see where it is. No, so here we go.
I saw something about he failed at IOP.
Yes. So second. Probation, could I have the attachments for the compliance hearings?
Yes, Your Honor.
Thank you. And can you find out what is Mr. Gomez, is he in custody? Or if he's on bond? Because he hasn't shown up.
He's on bond, he's out.
All right, if you could see where he is, please. Yes.
She's number 3. During what I'm, does she then become number 2? Did she quit? Or do they not get numbers? Okay, okay.
And it always remains the same.
Okay.
Like,
Alessandro.
so any update on? Oh, I thought you were coming to tell me, give me an update.
Your Honor, when I spoke with the CSO assigned this morning, he said that he had not been able to get in contact with him, but he left several messages. And I know personally, I emailed and sent a text message to him as well. So I'm just gonna make another phone call.
All
Just to
right,
be,
and if that's not answered, then it will be just follow motion.
yes, ma'am.
Thank you. Yes.
Two things. This is an off docket matter, but this is really to a request to allow for GPS for partial. The motion in and of itself is not necessarily clear, but
Okay.
I think we have an agreement to allow for partial GPS so that he's allowed to work.
That's the defense's understanding as well, Judge.
Okay.
Sorry, thanks, Judge.
And on this one, Judge, on Mr. Elizondo, I think we give it to them.
Yeah, we don't know what to do. You know, they should have done something better with that.
I talked to Karen when Judge Angelini was here. Pre-trial's already changed it to where he's able to do what he needs to do, so
Okay,
she didn't need to approach on it, because we had an agreement to like change it for the schedule, but she's like, oh, I don't even need to do it, because pre-trial's allowing it. He's not having problems anymore, so.
all right, thank you. Oh, yeah, fine. Mary Thigpen.
Her attorney says he's in trial on the 437.
Oh,
He's been in trial since last week.
okay, what is he trying in the 437?
I mean, the 407.
Oh, that's on the civil side.
Yes, ma'am.
And who's her attorney?
Ricardo.
So do they have an idea of when that will end? Because they do time announcements over there.
I don't,
Who's the,
I did ask.
all right, can you find out what is their time announcement? Because if they're,
Do you have? Do you have a-
407.
407.
Yeah, just find out what their time announcement is, because sometimes it's 1 week, sometimes it's more.
Judge, on this in-home removal, I think we just put him on probation and asked for ignition interlock, so I'm okay as long as some type of monitoring is happening.
Okay. All right, does it show in the system that he's on ignition internet?
Well, I don't know if he's like signed up for it, but it was ordered last week. I think it was last. But it was part of the plea.
All right, so let's recall this. Are we able to recall it sometime this week?
Thursday.
Okay, let's recall it for Thursday. Ms. Thigpen, we want to recall your case for Thursday. And am I pronouncing your last name correctly?
Yes, ma'am.
All right, thank you. We'll see you back on June 9th.
So Judge, it looks like you granted an order amending ignition interlock in lieu of the mobile device back on May 26th.
Okay,
So
all right, I'll make sure to put a notation in there if they're not to remove this until the ignition interlock is installed. Yes.
For Mr. Gomez, there was no answer.
All right, so just go ahead and file the motion and I will sign that.
Yes.
All right, and just give me a moment. ones.
Yeah, Kenneth Jones.
Hmm?
Kenneth Jones, yeah.
Looks like we have Kenneth Jones. Where's Kenneth Jones? Who says,
He's in jail, Judge. I gave you a motion for continuing.
yeah, no, I have this. Why do you keep saying they're ready? It was like, where the
Oh, no,
defense?
I had told him to put it up there.
I'm like, they're ready and I don't have a defense attorney.
The defense attorney's not here, Judge. He filed that. He had a vacation.
I know, but this is not a proper motion for
Oh, well,
continuance.
Judge, that's what they emailed me. I have,
Yes.
I don't know what to tell you.
Tell Mr. Jesse Hernandez, because this is the law of Jesse Hernandez, that he needs to be here. Somebody from that law just needs to be here. All right, and Mr. Blunt,
Victoria's still looking at that. I was just gonna announce to you on my contested, there is gonna be a plea of sure, Judge.
all right, thank you.
Whenever you're ready. David.
Oh, yes, that's that. Okay,
Maybe that's.
We did turn in the acknowledgement on Mr. Blunt, Judge. It's already been signed.
yes, I signed it. Okay, just give me a moment.
Kenneth Jones.
Yeah. I know. But his motion for continuance has been filed, and it's not, there's no notary, there's no certificate, there isn't anything. I'll go to the rules.
GPS on it. It's bad because he's like all the way in line, and then they were like, you brought the wrong form. It's like the typical GPS thing. Yeah, but we didn't, yeah, they didn't indict it that way. They just went with retaliation. I mean, it's kind of shady. They're protesting it. She's just working at the place. Or, yeah, let's look at that. That's his first name.
No, it has to be notarized. Motions. Motions for continuance have to be notarized. That's okay.
She said she called two this morning.
And they're not following the rules.
Okay. I just told her it has to be notarized.
Yes. And if I could check the file, it's
Get it from my name.
2021 CR 2772. All right, thank you.
Figure that out. She's gonna work with the notary. She's a notary. She just notarized it somewhere?
No, he has to sign it saying that all that is put in that motion is truly correct. And he has to sign it.
Oh, she told me this was the certificate. This is correct. And so-
No, no, no. It has to be notarized.
Oh, that makes sense.
This is the water. That is.
Well, we didn't have any, but most of the time it's that one up here. But it like goes out, like when I first bought it, it was like $10, and now it's like $24. Inflation is still the same.
And Norma, that matter you called me about, Forrest, is he showing up today?
No, Judge, yes, not. I found the docket in tomorrow. Make sure you show up.
All right.
Let me come over to my- Yeah, fine.
All right, are the parties ready on Felipe Salazar?
Yes, sir.
All right, if you could approach, please. Court is calling 2022 CR 1223, State of Texas versus Felipe Salazar. Now parties announced for the record, please, for the state,
Marcus Sanders.
for the defense.
Paul Giltry representing Mr. Salazar, Your Honor.
And are you Mr. Salazar?
Yes, ma'am.
Defense of showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review it with your client?
Yes.
Yes,
Yes.
ma'am, I have.
All right, the court will find that the state is in compliance with the discovery. Mr. Salazar, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we're proceeding on count 2, waiving count 1.
That's my understanding, Your Honor. There's no
Any
objection to waiver.
objections? Any objections?
There's no objection to the waiver.
Mr. Salazar, I'm showing you what's entitled Application for Deferred Adjudication. Did you review this document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Next, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit or Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with in count 2, failure to stop and render aid with a moving vehicle. The range of punishment for that offense is up to 5 years in TDC or prison with a possible fine up to $5,000 and up to 1 year in the Bexar County Jail. Did you understand that to be the range of punishment?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, the right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication and for any reason it were revoked, the court could sentence you up to 5 years in the prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any offenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
And that's my opinion.
Do you believe he's currently competent and was legally sane at the time of the offense?
Those are my opinions, ma'am.
Mrs. Salazar, has anyone threatened, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargaining agreement to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review this page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $500 fine. State opposes your application for deferred adjudication. State recommends community supervision.
That's the.
There's to be
probation.
restitution payable to Andrew Gomez and Carolyn Haywood. There's to be no contact with Andrew Gomez or Carolyn Haywood. Did you understand that to be the agreement, Mr. Salazar?
Yes, ma'am.
Defense, is that the agreement?
That is the agreement, ma'am.
State, is that the agreement?
And Judge, I apologize. There's a couple corrections.
Mhm.
Andrew Gomez was named in the indictment, but he's not a victim, so we can remove his name from the restitution as well as the no contact. And then we also agreed to TIC County Court Case Number 671850.
And that is correct, Your Honor.
All right, if you all would like to initial and remove the part that you wish to remove. So then, according to the plea bargaining agreement, the punishments to be assessed at 5 years in the prison. There's a $500 fine. State opposes your application for deferred adjudication. State recommends community supervision. State will take in consideration 671850. There's to be restitution and no contact to Carolyn Haywood. Did you understand that to be the plea bargaining agreement?
Yes, ma'am.
Defense is at the plea bargaining agreement.
That is, Your Honor.
State is at the plea bargaining agreement.
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have any such motions?
There are none, Your Honor.
Next, I'm showing you outside the plea bargaining agreement. The state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 150 hours of community service restitution, and the aggressive driving course. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 2 in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence.
Yes, the state offers states exhibit 1 and its attachments.
Any objections?
No objection for the purpose of this proceeding. Ma'am.
Mr. Salazar, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review this document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Just a moment. All right, so there's extra writing here.
Yeah, it's
About
set
the
up as a
defendant.
no contest plea, ma'am.
No, I know it's a no contest plea, but he's entering this plea and he doesn't have the right to remain silent if I want to ask him questions about this case.
Oh, yeah, there's an addition there. It says unless and until. One never knows what questions are coming. I doubt you'll ask them about some other crime, but these rights are continuing rights and can be urged by you at any time in the proceeding. And so it's a theoretical possibility that something outside of this matter could be asked of him by the prosecutor judge, theoretically. And
No,
for that reason,
I understand what you're saying, counsel, but no, that can't be in there. If he wants to invoke his right to the Fifth Amendment, he can do that. But for any question related to this case, any question related to this plea, he's giving up his right to remain silent.
That's
So
what it
adding that
says.
caveat, well, then that needs to be removed because it already says it in there.
oh, okay, I believe that it says exactly what you're saying, but if you're recognizing that, well, it's really not important. It's just an abundance of caution.
If you don't have to find and show that, please.
Here.
Thank you.
There you go. Yes.
So, Mr. Salazar, you do understand by entering this plea bargain agreement, you're giving up your right to remain silent in this case. You understand that?
Yes, ma'am.
And knowing that you still wish to go forward with this plea?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. court will accept into evidence states exhibits 1 and attachments and review the same. All right, reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am, we're ready to proceed if the court will let me make presentations to the court about some issues.
Yes.
So if I'm a little bit less than direct, it's only to be very, very polite. Mr. Salazar has some difficulties with things that are complex, maybe not so complex for you and for I, but you find some things complex that ordinarily one wouldn't find complex. The reason the state is not recommending a deferred adjudication is that he has a prior offense of this nature. And that is because he does have some difficulty with complex issues. It's kind of like intellectual limitation, difficult to argue.
So why is he driving?
No, it's not like that. It's just he has trouble with complex issues, not mechanical skills, not motor
So
skills.
it's complex to stop if you're at an accident?
Well, so he has a misunderstanding about something, Your Honor. It's actually a type of crime in some countries in Latin America to have a motor vehicle collision. It's a crime in the civil realm. And somehow or another, he was confused about that. I have explained to him that if he has a collision, he has to stop and stay at the scene. And he now understands that. He never really got that before. And that's why, and I didn't represent him in his prior plea.
Okay, so his prior plea, I'm assuming that someone told him if he was charged with, was his prior plea the same thing, failure to stop and render aid?
I think he had a prior offense like that.
Failure to stop and give info.
Right.
All right,
Yeah.
so he knows he needs to stop.
Well, I don't know that it was adequately explained to him because he has that kind of difficulty, Ron. I now know it's you understand now in a collision, you stay at the scene,
I'll
right?
stay there. Yeah, I'll stay there.
So how is he passing his driver's test if he doesn't understand complex things? Because the last time I took a driver's test, which has been many years, but they ask you questions like, you know, how many feet you're supposed to be behind a car. They ask you questions about when accidents happen, or if there's an emergency vehicle, do you pull over to the left or do you pull over to the right? So I understand this complex, difficult thing.
Yeah, those, what you've just articulated is not particularly complex. This is a concept that he just really didn't grasp in my discussions with him.
Okay.
I can tell you that, you know, I went to great lengths to break through that, but it's a simplicity thing, if you will.
I'm just having a hard time understanding what is complex about, I hit a vehicle, I need to stay instead of going blocks away or wherever he was, I don't know how many miles it was, changing his tire. And he had damage to his vehicle and damage to the other person's vehicle.
He gets that now. I don't believe he got that before, Judge. This is my honest representation to the bench.
But isn't changing the tire complex?
No, not at all.
Okay. All right, I understand. Do you want to call him as a witness or not?
No, no, ma'am. No, it would just kind of No telling.
Okay, all right, state you're opposed.
Yes, Judge. Our opposition is because he's committed a similar offense back in 2013. He was convicted of it. He's been given deferred on a lesser ground before, so he's been on probation. He's been given opportunities. He's still committing offenses. Don't necessarily buy the defense that Mr. Goki is raising, and so that's why we're asking for probation as opposed to defer.
And in brief reply, he didn't necessarily buy it. He's not interacted with the gentleman to the degree that I have. I'm telling you, I have encountered this kind of.
No, I
intellectual
understand, and
challenge.
I understand you have a different communication with him, and the state hasn't.
Right.
Communicated with him.
Right.
So I see here aggressive driving course. I don't think he needs an aggressive driving course. I don't think he needs to be driving. And isn't the aggressive driving course, won't that be complex?
Well, so I don't know, not having taken it. I'm telling you that I have had some difficulty explaining some things to this gentleman. I am confident that his waivers are voluntary and he knows what he's doing here.
And he's confident.
Oh, yeah, yes, yeah. But there's a whole range there, ma'am. I'm just telling you that he has some communication difficulties, I have found.
All right.
So I just ask you to not give him, to give him a final chance to not have the effects of a felony conviction on his record. That's what I'm asking for.
All right, Mr. Salazar, is there anything you wish to say?
No, ma'am.
You sure?
You can talk to her if you want. You want deferred adjudication so you don't have a felony conviction on your record?
Yeah, I want.
Are you gonna obey the law now?
Yes, I obey the law now.
You now know if you run into somebody or they run into you, whatever,
I'll
you
stay
have
there.
to stay there.
Yeah, I'll stay there.
Well, I mean, state you have questions?
I do, Judge. Has he been sworn in or?
No, he was sworn in by the clerk,
Okay.
so he's under oath.
Okay. Mr. Salazar, where were you born?
San Antonio.
Okay. So when your attorney mentioned other countries that not being an offense, you're aware that it's an offense here, correct?
Yes,
Okay. And did you grow up here in the United States?
yes.
Okay. Have you ever lived outside of the United States?
No,
Okay. And when you committed the offense in 2013, you were placed on deferred for that? When you hit a vehicle and you drove off?
Mhm.
What did you learn from that incident?
I just, I need to stay in, where the accident was.
Okay, so you did learn that back in
Yeah.
2013.
I just got scared and just took off.
Okay, no further questions, Judge.
Any other questions, Mr. Goku?
Yes, so Felipe, when we were in the back, we were talking and I asked you, well, why did you leave? And you said to me, because I was afraid I would be arrested, right?
Yes.
And I told you, well, you wouldn't have been arrested if you hadn't
scared.
left,
Yeah,
right?
yeah.
And then you said that you always get arrested if there's a collision, but in fact, you had
Yeah,
left before, right?
Yeah, I left it. Yeah,
You now get it that when
sir.
there is a collision, you stay.
I'll stay. Yes, sir.
Yeah, it was, I'm telling you, there's some communications that were very, very difficult for me, man. That's what I'm trying to say.
So, Mr. Salazar, so what you're saying is you left the scene because you thought you would be arrested?
Yes, ma'am.
Okay. All right, are you employed?
Working, yes.
What do you do?
Diesel mechanic repair.
All right, I don't understand the aggressive driving course request because this is an aggressive driving issue. I don't see anything to suggest that he was driving aggressively. I think this is he doesn't stop and give information like the law says he's supposed to. So, you know, he needs a course on give information when you're in an accident.
He got
I
that
just
from
gave you
me.
the course.
Yes, ma'am.
All right, This is what the courts do. Court's gonna find you guilty, sentence you to 5 years in prison, suspended and probated for 5 years. There's a $500 fine that will be probated. Taking consideration 671,850. Restitution and no contact with Carolyn Haywood. 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. There's to be regular reporting to probation by Zoom or in person. If you're drug tested today, what are the results going to be?
The judge is asking you if you take any kind of drug.
Oh, no.
Okay. There'll be regular UAs. Field visits, 1 time per month, regular. And I'll put in here the aggressive driving course. Once you complete the aggressive driving course, the remainder of your of your community service hours will be waived. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else that he needs?
No, Your Honor.
Mr. Salazar, is there anything else that you need from the court?
No, ma'am.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right, Mr. Duffy,
Oh, thank you.
because this is a plea bargain agreement, because you waive your right to appeal, and because I followed your plea bargain agreement, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, ma'am.
Do you understand that if you're involved in an accident, you must remain?
Yes, ma'am.
All right, is there anything that you don't understand about the law of failure to stop and render aid, or failure to stop when involved in an accident?
I understand now.
All right, thank you. Probation will be out to talk to you. Good luck to you.
All right, thank you.
You're waiting for probation.
Yeah, he's coming up next. Okay, sure. David Hernandez. What is calling 2021 CR 1005W, State of Texas versus David Edward Hernandez. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Raymond Martinez.
And are you Mr. Hernandez?
Yes, ma'am.
Show you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same David Edward Hernandez who was placed on deferred adjudication in 2021 CR 1005W for the offense of assault family second on February 3rd, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 9th day of February 2022 in Bexar County, Texas, the defendant David Edward Hernandez committed the offense of violation of bond or protective order in violation of condition number 1.
How do you plead to that? True or not true?
It's true.
State.
Violated condition number 21, on or about the 9th day of February 2022 in Bexar County, Texas, the defendant David Edward Hernandez did then and there contact or attempt to contact Savannah Hernandez or a family member by telephone, mail, or in person in violation of condition number 21.
How do you plead to that? True or not true?
That is true, Your Honor.
Did you understand by pleading true to violations of conditions 1 and 21, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of conditions 1 and 21?
Yes, Your Honor.
All right, is there an agreement?
No, Your Honor.
All right, state, what are you requesting?
State is asking for revocation in this case, Your Honor. This is a case where he's been placed on probation for a violent offense against a previous girlfriend, that being the person listed in violation of condition number 21, Savannah Hernandez, which, as you can see, linking up condition number 1 and condition number 21, this is the same person he's on probation for. He's not supposed to be contacting. the same person sitting in this courtroom today. Because, obviously up until the day we were set for contested. We're asking for revocation in the sense that you just can't leave this person alone. And at this point, the state feels that in order to secure the safety of the victim, we're asking for revocation because hopefully prison will be the impediment at this point because probation wasn't enough for the defendant to stop contacting Savannah.
Right, defense.
Judge, Mr. Hernandez is actually Mr. Hernandez's ex-wife. They just finalized a divorce in February or March of this year. The evidence that we would have presented today, Judge, and we still have witnesses in the court that could present is that these parties have engaged in a consensual conduct with each other on an ongoing basis, even since the protective order was granted, because they were legally married. We've shared with the state text messaging back and forth, phone calls, Facebook posts. But Mr. Hernandez ultimately decided to plead true because I've made it clear to him that regardless of whether she consents or does not, regardless of whether she invites him to her house or not, that he's not allowed by law to do that. And so instead of spending the court's time defending why he was having contact with her, he decided to plead true and explain to the court that's what was happening. There was a period of time between the time the protective order was granted and the time the divorce was granted this year, which is about a year, that there was discussions and attempts made at reconciliation. And again, Judge, he clearly understands after much consultation with me that she cannot waive the effects of the protective order. She cannot voluntarily agree with him that it doesn't apply anymore. And so all that's crystal clear at this point, Judge. As a matter of fact, we've shared with the state that on the date in question when Mr. Hernandez was arrested for the MTR that was issued by the court, that they were in the same car together, that in fact she drove his car home or wherever she took it after they separated. I think she now understands that her conduct in that regard is also placing him in danger. Judge, he spent some days in jail on the motion to revoke probation. As you can see from the motion itself, these are the only violations he has in over a year on probation.
So I don't, what the court doesn't understand is I know on the document sheet, which I wrote, I said, no contact with Savannah Hernandez. And I know when I place people on probation and there's no contact, I always tell them that relationship is over. What part did your client not understand when I said that relationship is over? That's what I don't understand, because I tell people your relationship is over, get an orchid because you're not ready for a relationship. So I'm trying to figure out what part of my order that he was not to have contact with her did he not understand?
I think the part he did not understand, Judge, is when she invites him to her house, when she says she's not ready to get a divorce, when she responds to communications that is not an exception to the orders of the court. And the reason we were set for contested hearing today, the reason we reset this matter a couple of times is me going through all of the history and explaining all that to him, that none of that is a legal significance to this court. And thus his decision that I'm going to plead true, because I get it.
Well, somebody probably, if there should be a witness that's called before the court so that I can discover why there is being contact when I order no contact. And the court would like to know if both, if the complainant, and I don't have any jurisdiction over the complainant, but I would like to know if the complainant was okay with this defendant violating this court's orders by, you said, being in the car with him, trying to make their marriage work. I would like to know this before I make my ruling.
I certainly can't speak for her, Judge. All I can tell you.
Well, someone needs to call a witness so I can make an informed decision.
I would be happy to do that, Judge.
She's here,
All right.
so she can testify.
Yeah, I would like to know what's going on and why the court's orders are not being followed and why adults can't understand what I mean when I say a relationship is over and there should be no contact.
Would you, and the state can call her as a witness and say, we'll call Savannah. Do you want her to testify here?
Yeah, she can move over there, and Mr. Hernandez, if you go to the back, please.
And the state would call, for purpose of the record, Savannah Jimenez, previously known as Savannah Hernandez.
All right, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand if you'll state your name for the record.
Savannah Jimenez.
All right.
Ms. Jimenez, as far as your contact and your communications with David are concerned, were those consensual interactions?
I apologize to that I might lose my composure. The entire marriage was him making the decisions and me submitting to everything and anything that he said. So the meeting may have been okay. Let's go sign the divorce papers so we can get this over. But when I asked him to leave, he wouldn't leave. And almost every encounter was just for his gratification.
Did you, after he was placed on probation, did you intend or did you wish to have further communications with him?
No.
And were there times or periods of time where he would repeatedly call you?
Yes.
And just by example, how many times in a row would he call you and you wouldn't answer?
A minimum of 30 if I was at work or driving.
And would he continue to call you until you answered the phone?
Yes.
And again, this is all after he was placed on probation in this court.
Correct.
And the contacts that you had with him, whether that be via text message, social media, in person, or by phone, did you feel that you had a choice in whether you had to communicate with him or not?
No.
And why is that?
Because even if I said no, he was still gonna come. His threats to me were real.
I'll pass it.
Defense.
Ms. Jimenez, you're aware that the allegation is that he made contact on February the 9th of this year, is that correct?
Yes.
Isn't it true that what caused that to come to light was that he had a picture of himself sitting in your living room in your apartment?
I did not see any picture.
And he sent that picture to a person that you were in a relationship with, and that's what caused the fuss. Is that fair or no?
No.
So you had to have reported the violation, or we wouldn't know about it, correct?
Correct.
Okay. So on February the 8th of this year, was Mr. Hernandez sitting in your living room, and he has a picture of the two of you sitting in your living room.
The picture I did not know was taken. I did not give consent for him to take a picture of me or to send it to anybody, which he sent it to at least a minimum of 8 people. And it was because he had already finished his gratification. And he was sitting there and I had asked him to leave repeatedly and he wouldn't. I have to threaten him every time with calling the cops. I did not want him to go to jail, but he doesn't comprehend it. That's the only thing that I can think of. And his mindset is I was just property. And I'm not gonna.
Now, Ms. Jimenez, we're talking about your apartment, correct?
Yes.
So he can only get in there if you let him in, correct?
Yes. Every time he came, it was just banging until he came. And the only time that he did leave was when I called the cops because he saw me calling 911 and I was standing in front of the window when he left.
But we don't have a police report from this incident in Ukraine, correct?
That happened on the same day.
So you're saying that you can't, while he's locked out and can't get inside the apartment, you can't call the police and have them remove him?
I did. That's why he left. That's the only time that he left.
Now, in reference to the text messages, we've shared with the state and the state shared with you printouts of text messages, very many text messages. True or not true? Very many.
I did not see, but yes, I saw some paperwork.
So tell us how he's forcing you to respond to text messages.
Because he told me that if I didn't do what he said, that he was gonna kill both of my grandmas and leave me alive to suffer and not kill me because he knew that would kill me.
And Ms. Jimenez, when have you shared that particular story with anybody?
I didn't want to have to share any of these stories. I did not want to have to tell people that he had forced himself to have sex with me. That's the only reason why he wanted to continue our marriage or our relationship. I did not want to have to tell anybody. He had threatened to kill my family. I did not want him to say all of this, but I know I have to. I have to because he was getting worse because I was trying to make him stop and he wouldn't stop. Trying to take it so much. He was gonna try to take my job and show my family pictures of me being indecent. Nobody wants. Nobody wants that.
Do you need a minute or do you think you can?
I can continue.
I mean, Ms. Jimenez, on the last date that Mr. Hernandez was arrested, you were in the car with him, correct?
Yes, that is correct.
And you guys were going on base, Lackland Air Force Base, where he has to show ID and go through security guards.
That
correct?
is correct, yes.
And when they arrested him that day, you left in his vehicle, didn't you?
Yes, I did. He asked me to.
And not only did you leave in his vehicle, but you had his wallet with you, didn't you?
Yes, I did.
And you proceeded to use his debit cards and his credit cards.
That is correct.
Okay. And so, man, that you're so deathly afraid of, it didn't stop you from taking money out of his accounts.
That is correct.
Now, was I accurate that the divorce between the two of you just got finalized a few months ago?
In March, yes, before the date that you're talking about.
And in fact, you, not only did he come into your apartment, but there were occasions where you drove over to his house of your own volition.
I did not have a vehicle. No,
So the only time you drove to his house was when you had his vehicle.
when he picked me up. Yes,
But you see, my point is that you could have told those security guards at the front gate as you're going in that you were being held against your will, or that you were being kidnapped, or anything of the sort.
I only agreed to because I knew that would happen. I needed help.
And you agree with me that none of these things that you're sharing, a lot of these things you're sharing with the court today do not appear in any police report because you never made those.
No, I never did.
Professor,
Just a few questions. As far as when Mr. Martinez was talking about using the debit cards and the credit cards after he was arrested, trying to enter Lackland Air Force, I'm sorry, it's Lackland Air Force Base. Can you explain to the court why you used his debit cards or credit cards?
Yes. We had already made plans to go to the bowling alley and to go to the movie theater. And every decision since day one has been decisions that he's made. Never have I once been on his bank account. I have never had a debit card in my name. My both jobs were direct deposited into his bank account. So I never had any money. This was our typical form of me being access to his money, is using his card. I never had anything in my name. No decisions word made of my own choice. It was whatever he said.
Okay, and specifically, you know, you said your divorce was not finalized until March of this year.
Yes,
You know, around February 19th of 2022 to this year, where your money is still being deposited into his accounts.
all of my money had always gone to his account for both of them. The checking account was only his VA compensation, and my money was going to his savings account. We had my checks going into his account, and what we had decided or spoken about, the main reason how he was able to allow me to temporarily trust him was to get this divorce finalized, was that reason for everything to stop. I didn't know how to make it stop.
Okay, but as far as February 19th of 2022 is concerned, at that point you were in divorce proceedings, correct?
Yes,
And so is there a reason you didn't have your money deposited to a separate account to use?
for the accounts, I did set up a chime in my name. It had been just taking maybe 4 paycheck cycles for that change to go over. So we had agreed that he would keep the house because he had nowhere else to go. And I said that was fine. And it had initially started because he had a relationship with another woman. And I had said, okay, I'm going to be the bigger person and let her stay there as long as she pays half of the mortgage. And he said, my lawyer said that I have to financially support you until it is final and over. Whether that's a true statement or not, I'm not sure, but that's what he had informed me of. So that's the only reason why I continue to use his card like I had been before for the whole entire relationship.
Okay.
See, minutes, I thought you and Mr. Hernandez worked out the divorce by yourselves without the benefit of any lawyers.
He used your name all the time. I'm not sure if he paid for anybody or not.
Well, would you agree there's no lawyers' names that appear in the divorce?
That is correct.
So if we were to look at the bank statements that we provided to the state, we're going to find your deposits going in there and you regularly using those cards. That's the contact information.
There's no, yeah, so there's no way for anybody to know whether I swiped it or whether he swiped it, but that's, yes, typically I had no other access to my funding. There was no card in my name. So I'm not sure how you want me to answer that question, but yes, that's the typical. I didn't have any card to use that was in my name to pay any of the bills or to buy stuff at HEB. So yes, that's how I would pay for things.
Would you agree, Ms. Jimenez, that one of the things that you charged on the card when Mr. Hernandez was in jail was a dinner at a restaurant for over $100?
No. I went to Burger King. I went to the movies. I had popcorn there. I went to HEB. I went to a Mexican restaurant. I did not have a fancy, extravagant, romantic dinner with another party. No, there's no extravagant restaurant.
Sorry.
I know.
Sorry, thank you for coming to testify.
Thank you.
All right, unless there are other witnesses, the court will hear. I heard argument where you want revocation
Yes, Judge.
and you want him to be continued.
We do judge with whatever modifications the court feels are appropriate. And
Does your client wish to say anything?
say it again.
Does your client wish to say anything?
I was going to just say that, Judge, you might want to address a couple of those things. Yes.
Yes, Your Honor, we were trying to reconcile over the time between.
Excuse me, you haven't been sworn in.
Yes,
No,
ma'am.
ma'am.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
David Hernandez.
Mr. Hernandez, before we talk about that, I just want to address the last thing that we talked about. Was Ms. Jimenez being truthful with the court when she says that she had ready access to all your cards at all times? All your credit cards and debit cards?
That is not true.
Did she routinely, consistently, over the period of time that y'all were together, deposit her paychecks into your accounts?
That is not true.
So the bank statements we provided to the state, are we going to see any deposits from her paychecks?
There are no deposits of her paychecks on any of my bank statements I've provided.
And the last question I asked her about relatively large amount of money being charged at a restaurant while you were in the jail. What specifically was that?
There was one amount over $140 or $150 that was to a Mexican restaurant that I'd never even been to. And it was a huge charge. I've never even been there before.
And more importantly, Mr. Hernandez, on the date that that charge was made, were you in custody or not?
I was in custody during that day.
How was it that she had your wallet?
I had left it in my truck when we were picked up at Lackland Air Force Base, and it was just, I didn't know if she knew it was there or not, but she found it. And that day we were on our way to go bowling and movies. So, I mean, it was in the vehicle.
Mr. Hernandez, has there been contact between you and Ms. Jimenez since the divorce has been finalized?
No contact.
Phone, email, text, social media, anything?
No social media, no phone, no text or anything.
Did I state accurately your position that you understand that regardless of why and how these contacts occurred during the time you were still legally married to Ms. Jimenez, that you're prohibited from doing that by the court order as well as the protective order?
I'm sorry, I didn't
Do you understand that you're prohibited from doing that by court order and by protective order, regardless of whether she consents to the contact or not?
Yes.
So for that reason, and because the two of you have now gone your separate ways permanently, are you asking the court to continue your probation?
Yes, Your Honor, I'm asking the court to continue my probation. We have gone our separate ways. It is over and done with. Do not, we don't have any children together. We don't have any property that we have an agreed to the divorce together. We will be selling the house. We will both be selling the house through a realtor coming up soon. And all of that has already been in order, and there's been no contact since the 19th of February. There's been no contact or anything. And I understand I was wrong. And I understand I went against your word. And now I know that how serious and possible, damaging it is to me. And just, I understand now, Your Honor.
Mr. Nez, is there a reason why you guys weren't at Lackman and you have a military ID? Why do you have that?
Your Honor, I'm 100% disabled veteran with post-traumatic stress disorder. And I see my therapist every 2 weeks. And I have regular appointments with my therapist, and I'm in therapy with the VA. And that's the reason why I cannot work, because of panic attacks and because of stress and anxiety to the point to where 3 different doctors had diagnosed me at 100%. That's the reason why I had my veterans benefit card and that day to go bowling that day.
And you also understand, Mr. Nez, that the court has the option to modify your conditions of probation in whatever form the court feels is appropriate.
Absolutely. Yes, I understand that. Yes.
Do you have children, not with Ms. Jimenez, but with somebody else?
Yes, I do. I have 4 children. One is in his final 2 years of high school. I do pay child support for him. And I do help out with the school and with his band boosters and his ROTC boosters.
Are the other children that were adults, are they also somewhat financially dependent on you?
Yes, they are. I help take care of my grandson, and I help with things like as far as clothing and food and things like that with my grandson. And my oldest son is trained to become an EMT, and my daughter is a medical assistant. And my third child, he's dependent on me because he has a lower paying job, but he's trying to make his rent and everything. He's trying to live on his own, but I'm financially helping him out with my compensation money.
As far as your prior record, Mr. Hernandez, you had a prior for family violence assault 2008, is that correct?
That is correct, yes.
Was that a probation case as well?
Yes, it was.
Did you complete that probation successfully?
Yes, I did. Yes.
And since then you got this case a little over a year ago.
Yes.
Is that the entirety of your criminal record?
Yes, it is.
There's no other charges here or any other count?
No, no other count. No.
That's what it's just.
Steve?
Mr. Hernandez, so you talked about specifically violating this court's order, but you were aware that there was a protective order in place as well, correct?
Yes.
Okay. And specifically, I'm going to show you what's been marked as State's Exhibit number 1. The agreed protective order. That's you, David E. Hernandez, right?
Yes.
Okay. And again, this protective order, which was agreed, under it, you are prohibited from having any contact, right? Under subsection C.
Yes.
Okay. This doesn't tell Savannah to do anything, right? This tells you to do something, right?
That's correct.
Okay. Is your or was your phone number 210-573-9345?
Yes.
Okay. And your email address was speqrdh@gmail.com?
Yes, it is.
Okay. So you'd also agree that not only did you communicate with her via text message, you also communicated with Savannah over emails, right?
Yes.
Okay. And specifically, you sent her numerous emails.
Yes.
Okay. I'm going to show you what's been marked as State's Exhibit number 3. That's that same email address that you said is yours, correct?
Yes.
Okay. And then you email her to call me right now. I'm coming over tonight soon, right?
Yes.
Okay. Why did you email her that?
Because she had wanted me to go over earlier, and then she changed her mind. So I said, why, I was like, why did you change your mind? Call me now. I'm coming over soon.
So even her changing your mind, you're still going to come over tonight.
Apparently that's what I wrote.
Okay. I'm going to show you what Parker State's Exhibit number 4. Again, that's that same email address that's yours, right?
Yes.
Okay, and so you emailed Savannah on Sunday, February 13th. Since you don't want to talk to me, that's fine. I will just leave your part blank. You already signed the waiver, so whatever the judge sees that I wrote down is what he's going to go by. Since you don't want to call me or talk to me or make a plan to sign any paperwork because you just get so mad all the time, then it's going to cost you in the long run. Thank you for the house. If I sell it, I'll get in contact with you. If not, I'll just let it go to foreclosure and ruin your credit. It don't matter to me anymore, right?
I was talking about the sale of the house because she agreed to that we're going to go and sell it together. And then she didn't want to answer about, we were trying to make a plan on how to sell it and how we're going to divide it and things like that.
Right. But that first line you said, since you don't want to talk to me, right?
About the sale of the house.
Right.
Yeah.
Okay. So clearly she didn't want to talk to you, but you still wanted to communicate with her.
How else are we going to be able to sell the house? I mean,
even though you know that there's that, what I showed you State's Exhibit
Yes,
number 1, you're not supposed to contact her at all.
Yes.
Okay. I'll show you what's been marked as State's Exhibit number 5. You can see again, it's all you, D. Hernandez, right? And this is just kind of a snippet. Did you contact her about work, about USA? I'm messaging your work, sending them your pics.
I don't remember saying that, but apparently that's my email. So.
Okay. Somebody else using your email?
No, no one's using that.
Okay. And then later that day, I'm kind of come over tonight. Previous to that, yes, I'm jealous. Right? All you. Show you what's together. State's Exhibit number 6. Again, we see 1, 2, 3, 4, 5, 6 emails, right?
Yes.
All your same email address, D. Hernandez, right?
Yes.
Okay. Specifically, at 3:54 PM, Jesus Christ, I'm trying. I do love you. Answer me. Right?
Yes,
Okay. Was she not answering you?
I guess not.
What? Are you calling her?
I don't remember.
Okay.
Maybe it's response to him trying to email her.
Okay. That was just for clarity purposes. Brevity, States Exhibits 7 and 8. Right, you can agree with the exception of this top one right here, which is yieldstreet.com. These are all from you.
Yes. They were mostly talking about going out to dinner and breakfast and things like that.
Your Honor, at this time, the state would move to admit States Exhibits 1 through 8. Which are just the exhibits that we just went through.
Any objection?
Judge, unless it's established that they're during the time period under which the predictable was in place, then they're not relevant.
Your Honor, they're all are honor about, and most of these are
Did you
specific.
have a chance to see the exhibits, Mr. Martinez?
Not this minute.
Okay.
Judge, I would renew my objection that there's nothing on the document itself that suggests it's during the period of time in which the particular order was in place.
All right. States Exhibits 1 through 8 are admitted. All right. Any further questions?
Can you remind me what your testimony concerning your criminal history was again? You said you had one prior ABI assault case,
Yes, in 2008,
and then what else did you say was your criminal history?
2020,
And what was that?
it was the assault, violent injury, family domestic violence, November 2020.
Those are the only two things you've ever been arrested for?
In 1995, it was a domestic, and it wasn't domestic, it was a assault violent injury.
Do you remember in 2008, you also had a violation of protective order? In 2000, you pled to that and you were sentenced 16 days in 2009?
Yes.
Okay.
And dismissed.
So you were sentenced to, you actually went to, you were sentenced to 16 days in jail for that case.
Spent 16 days in jail, but it was for a violation of protective order, but it was, all of them were, there was, well, it was dismissed.
It was dismissed, but you went to jail for it?
Your representative on that. It was an issue going over and over and over again. Okay.
And then in 2009, you also got 18 months of probation for a violation of protective order, right?
So,
And then also in 2009, you had 16 days for harassment case.
yes.
Okay, so that's your true full criminal history, right?
Yes.
I'll pass it.
Right, defense.
So, Mr. Hernandez, you, in response to the state's question, you said, yes, I'm jealous. Was she, is that in response to a question from her asking if you were jealous?
I believe so.
So can you think of any other reason why you would have told her that in the way that you did, other than her asking you that question?
Because she had told me that she had already met somebody else and even though we were still married, you know, just asked if, you know, if, does that make you jealous? because I met somebody else and I just said something like, yes, I'm jealous.
Now, did she sometimes, without prompting from you, send you emails of that sort?
Sometimes, yes.
And that's what you're responding to in that particular response?
Yes.
Okay. And so when she portrayed herself as being basically in a no-win situation with you and no way to find a way out, she in fact is a good while back started a relationship with somebody else.
Yes.
And didn't hide that from you.
No.
Matter of fact, told you about it and told you who he was.
Yes.
Okay. And that's the same person who stood here and said she was deathly afraid of you. At least that's what I heard.
Yes.
That's all I have, Judge.
Oh, I do have a question. What is this about sending pics to work? I don't understand that. I think that was a question and it was asked, yes. So what is the sending pics to work about?
I
And
didn't
I don't
have
know if
any,
anyone wants to follow up on that.
Well, I will, Judge. So, Mr. Hernandez, you've heard, not necessarily through this hearing, but before we started this hearing, that she's worried that you might have pictures and or videos of her that she would not want to be shared with other people.
that's correct.
Do you have any such type materials?
No, I do not.
Was there a time in the past where she shared intimate information through either video or phone, or pictures with you?
Yes, there was a time.
Okay, and what did you do with that material?
I deleted them. Any kind of material like that, any kind of material that was revealing or anything like that, I deleted them. I didn't keep any of that stuff.
But my question is, because the state asked him about, I guess, an email or a text message where he said he was sending pics to her work. So I'm just trying to figure out what pics are we talking about? Because he said, yes, I did say that. So what pics are we talking about that are being sent to her work?
I did say that, but there was no pics that I sent. I did say that in the email, but I did not. It was just something that I told her to make her think, I guess, that I was going to send it, but there was nothing I had.
Why?
Just, I guess, angry over the jealousy.
And what pics?
Sorry,
What pics?
I have no pics.
No, I mean, what pics did you want her to think that you had that you were going to
The
send to her
old,
job?
some old pics or videos that she had sent me a long time ago before, but I even told her and explained to her that I don't have them. So when I said it again, she should have just, she shouldn't have known, but I mean, she didn't send me anything updated or anything. So I'd gotten rid of them, but I guess I wanted her to think that I still had them, but I didn't have them. And I was not going to send anything like that to her employer or employment.
And just to make very clear about that, Mr. Hernandez, have you sent those pictures to anybody ever?
No.
So the only person who ever saw what she sent you was yourself.
Correct.
And those items no longer exist.
They no longer exist.
Do you even have the phone or device in which you had them originally with you anymore?
No.
And what about the photo on the couch that was brought up?
Judge, that's just a generic photo of somebody watching TV on the couch. There's nothing.
No, I mean, who did that pic get sent to? Because you all questioned.
She testified that was her immediate boyfriend.
Okay. So he sent a photo of himself on the couch with her to the new boyfriend. Is that what I'm to understand?
Well, to show that they weren't necessarily together. In the picture, it doesn't show them together. It just shows that they're both in the same apartment.
Okay. All right. Is there anything else?
I have no other questions.
All right. Any other argument?
Just one last thing for Mr. Hernandez. Mr. Hernandez, you talked about your disability rating from the Veterans Administration, correct?
Yes.
And had you previously provided that information to me in terms of the entire report from the doctor?
Yes.
And in the past, had you applied to the Veterans Treatment Court as part of your legal issues revolving around this particular case?
Yes, I have.
But for some reason, they decided not to accept you, and that's why we stayed in this court.
That's correct.
Okay.
That's all.
Thank you. So I'm going to find the defendant guilty. The only issue is whether I'm going to send him to prison or he's going to be on probation. And so if you all will give me a moment just to think about that, but if you could take a seat in the box. And Mr. Martinez, you have Mr. Blunt. Could I have parties approach on Mr. Blunt? So you say your expert is not available?
This week, Judge, but I asked him, in anticipation of the court's questions, I asked him to give me for the next period of time, his dates he's available, dates he's unavailable, and I've shared those with the state as well, Judge.
So when is he available?
Judge, I can print it out. We were thinking it might be good to have this case set for trial end of December, or sorry, end of September, early October, not December. But I can look at I can print from the computer the actual availability that Mr. Martinez sent me.
All right, so any dates? I'm assuming July.
There were a number of dates that I think he was not available in July. Let me grab the calendar.
And Judge, I know you don't have it in front of you, but I did attach it to my motion. That's why I don't have one physically with me right now.
Let me see, I have the motion. And thank you for putting a notarized statement with your motion for continuance. I have to tell attorney. Sure. So I appreciate that. So in just 1 second, we're going to get with Ms. Ferguson, and we're going to go on the record on this. Who is that? It's Monday. Thank you. All right, how long are you, oh, there are no dates on here, but how long are you expecting this trial to last?
There's a lot of evidence. Both sides have experts. I think this is going to be a longer one. I mean, probably at least a week, I would think.
We'll probably be going to the jury on punishment, Judge, so that might add to it as well.
All right. So Ms. Ferguson, what are the dates in September?
And Judge, in September, I know their experts unavailable the 12th through 16th and September 20th. So we were kind of hoping for maybe the week of September 26th.
All right, let's see what date Ms. Ferguson gives it.
And Judge, just to add to that, I think my client has family that are out of state, and there may be some pertinent witnesses out of that group, and so they certainly need to make plans as well to come to Texas.
We can do that September 26th.
All right, we're gonna go on the record. Court is calling 2021 CR 1783, State of Texas versus Kendall Blunt. Now parties announced for the record for the state.
Michelle Hayden for the state.
For the defense. And are you Mr. Blunt?
Yes, ma'am.
All right, this is scheduled for jury trial. It's the court's understanding, at least we discussed off the record, that the defense, you're not ready because your expert is unavailable.
That's correct, Judge.
And both parties have agreed to a jury trial setting of September 26th. Is that correct?
That'll work, Judge.
State?
Yes, Your Honor.
And there is no objection from the state to the defense's motion for continuance?
No, Your Honor.
All right, then your case will be set for jury trial on September 26th. Ms. Ferguson, do you want them to come back on the 25th though?
It'll be on the 26th. I think that's on Monday. Judge.
Oh, you know, I'm looking at July.
Yeah,
Sorry,
26th is on a Monday.
that is. I'm looking at July. It truly is a Monday today. All right, so your motion to continuance is granted. We'll be back on September 26th at 9 a.m. And you'll need to be brought over, dressed for jury trial on Tuesday. If for any reason there's an issue with the clothing exchange, let the court know. Otherwise, Mr. Blunt, you'll be brought over, dressed for trial in whatever clothing you have at the jail. Do you understand?
Yes, ma'am.
All right, and the court has the acknowledgement of discovery. I have signed it. Defense, for the record, do you have all the discovery?
Yes, Your Honor.
All right, then I will see you all back on September 26th. All right,
Thank you, Judge.
you're welcome. And Mr. Black can go back. Mr. Black can go back.
Yes.
Okay, let me take. Which two? All right, Julian Sanchez, can I have a file on Julian Sanchez? No problem. And on Kenneth Jones, we're gonna recall you tomorrow. No, Kenneth Jones, just recalling for tomorrow, they need to have a motion with continuance. And then Julian Sanchez, who is Julian Sanchez, attorney?
Jackson Lindsay. Never texted and told him.
All right, Ms. Sanchez, we're gonna recall you back for tomorrow. And see if your attorney is present. If not, we'll see about scheduling another attorney for you. All right, so you can take her back.
No, just a quick right there.
Thank you. All right, and are the parties ready on David Edward Hernandez? Right, we're back on the record. And 2021 CR 1005W, State of Texas versus David Edward Hernandez. As previously stated, the court is finding, is granting the motion. The court is finding you guilty. There's an affirmative finding of family violence. The only question is whether or not I will grant you community supervision or whether or not I will send you to prison. Okay. Does anyone wish to speak with regards to that? State, I know you're asking for prison.
Yes, Judge, I think it's just based on exactly the testimony you heard from the victim here today, as well as the exhibits that are in front of you. I think that the defendant tries to characterize this as that this is some mutual consensual back and forth, but I think you can see from just, I know you've been a judge, you've been a defense attorney, but you're also a human being. You can just see from clear from the messages that he's doing whatever he can to get in contact with this woman. And he knows that he's not supposed to, not just from this court's order, but from a protective order. And so clearly probation, whether that's deferred or whether that's straight probation, is not enough of an impediment to prevent him from communicating with the victim in this case. And so prison is really the only next solution. And so there are other steps that we can take to protect this victim if the defendant is in custody with TDC, and ensure that he has no communication with this victim. Further probation is just going to prolong the issue of him continually contacting her, and not just contacting her, but contacting her and harassing him.
Right. So part of the court's quandary is that I've done a lot of family violence cases before as a defense attorney and as a prosecutor, and I do understand the circle of violence. I understand that. Part of the problem and what I'm wrestling with is the fact that she made contact with him, and I understand the mental issues and reasons behind that. But then I do know the other problem I have, because I know that happens. I do know that I inform everyone when I have a no contact order that the relationship is over. And I don't understand what people don't understand when I say this relationship is over. And I'm sure if I got the court reporter to pull the record, I'm sure I asked you something along the lines of, do you have any children together? And your answer would have been no. And I would have said, well, this is gonna be easy. Your relationship is over. You don't have any contact with her. And I'm sure I told you that you should probably not be involved in a relationship. And I'm sure I said, not to make light of things, but get an orchid. Did I give you the orchid speech?
I think you did, Your Honor. Yes.
And the orchid speech didn't do any good.
May I, Judge?
Yes.
I think all of those points have been made and reinforced with Mr. Hernandez many times before we got up here. But if you look at it, during that entire period of time, when he claims they were either reconciled or not trying to reconcile, there's not one incident of violence. He never went to her job. He never caused her any harm over there.
But my concern is he reached out to her and I told him there was to be no contact. I could understand if there's contact because they're in a civil court. I can even understand if there's contact because they're trying to sell a home. I understand those things. Sometimes people are like, but I really need to sell this home and we're trying to finalize our divorce. I understand that. But the contact that he's having with her is outside the bounds of, I'm in civil court, we're trying to finalize this divorce, or I'm trying to sell this home.
And Judge, we're certainly not here trying to suggest to the court that there should be no consequence to that. We understand there's consequences. And there's a whole array of things and options the court has available to deal some consequences. But what I think is also enlightening, judges, they did this divorce between themselves, by themselves, without any lawyers, regardless whether my name got mentioned or not, was not involved whatsoever. Since that divorce has happened, and this is several months ago, there hasn't been any contact. And so it is clear to him at this point. It took a while, but it is clear now. So we're asking the court to impose a sanction, impose a consequence, to keep vigilance on him, extend the amount of time if necessary on the probation. And there's monitoring, there's increased reporting, there's all kinds of things that are available. I don't think we ever once heard from this complainant that she called his probation officer and said, oh, by this way, he keeps calling me, or he's insisting on a relationship and I don't really want one. The fastest thing to get that to stop would have been a call to the probation officer.
But does she really have a duty to do that?
No, she doesn't have one,
Yes,
Judge.
it's on him.
It goes to the credibility, especially when you hear some of the other things that she said. She wasn't afraid to go take his cards and go spend $150 in the restaurant while he was sitting in the jail. So I think somewhat disingenuous, some of her comments. She doesn't have any qualms about rubbing in his face. Oh, I've got somebody else now. How does that make you feel? You know, we saw one side of the conversation. We didn't see the state offer into evidence her part of the conversation. So not making light of it, Judge, not trying to minimize. I'm just suggesting that the court has available sanctions and remedies that will protect this person to the extent that she needs to be protected, that don't necessarily have to involve prison. In light of his circumstances with his family and his personal health and all the other things, I don't see that the court would be taking a big risk in putting more restraints on him and proceed that way.
Oh, this is what the court is going to do. I previously said I found him guilty. I found him guilty. I'm going to issue a judge's warrant, and we're going to bring this back tomorrow, and tomorrow I'll make my decision. So we'll bring it back at 9 a.m. because I really want to just review everything. And my goal is always to make a just decision and make sure that the complainant has no concerns that he's out walking around. So what we're going to do is he's going to be taken into custody in the judge's warrant. I found him guilty, and we're going to bring him back tomorrow. And tomorrow at 9 a.m. I will make my decision on whether or not to send him to prison or whether or not to grant him probation. In between now and then, tonight, you need to think over what you've done.
Yes,
You
ma'am.
understand?
Absolutely, ma'am. Yes, ma'am.
Yes. Ms. Ferguson, are you able to bring this back tomorrow? And I'm not, if not, you can't, if not, that's okay.
Well, I requested, but they're short-handed, so we're
Okay.
kind of like.
All right, so they're shorthanded, so we're gonna have to bring you back on Thursday. That'll give you more time to think. Excuse me, Mr. Villarreal,
Yes, ma'am.
we're gonna have to bring him back on Thursday.
Yes, Judge.
Because Wednesday we have all-day jury trial. And since we are outside the time frame for us to order you back, so we'll bring you back on Thursday, okay?
Okay, yes, Your
And
Honor.
we put it on the docket, so your case won't be forgotten about.
Yes, Your Honor.
So we're back on Thursday.
Yes, Judge. Thank you.
Make sure that that judge's warrant is issued, and I'll make my decision on Thursday. Yes. Okay, sure. What's the 145? Okay, sure. All right, just give me one moment on that. Are we finished with our cases? Is there anything else on the docket?
You just have Acevedo left, she's coming back. Then we can recall it tomorrow.
All right, let me see that file.
And that's all I
Is she
have.
remanded without bond?
Yeah.
All right, let me see.
Let me go get it.
All right, thank you. All right, so we'll be back tomorrow at 9 a.m. Brenda, I come back after spending beautiful time with my niece. And you know what, Brenda, she doesn't have any complaints about anything. You feed her, she sleeps, she laughs, she smiles, so uncomplicated. But, oh well, so we'll be back at 9.